All rise. The Court of Appeals Division 1 is now in session.
You may be seated. Thank you. We are here today on our case number 1CACV180060, American West Bank et al. Versus Kellin. Counsel, as you know, both sides are allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings. We'd be grateful to you if, when you approach the podium, you would give us your name and the name of your client for the recording. We have reviewed the record in the case. We've studied your briefs, and we've also discussed the case in our conference. So with that, you may proceed.
Good morning, Your Honors. May it please the Court. I am Ryan Lorenz of the firm of Clark Hill on behalf of the appellant Sandy Kellin. Your Honors, this case comes before the Court after a somewhat unusual procedural path. The Utah District Court entered a judgment against Sandy Kellin after a post-real estate foreclosure deficiency claim. That judgment was entered against Mr. Kellin, and the judgment domesticated in Arizona. That occurred in 2014. The proceedings in Utah involved a writ of garnishment against an investment account of Mr. Kellin, which the appellee Banner Bank claims affects these proceedings. And in late 2016, a commissioner assigned to the Superior Court foreign judgment proceedings entered an order authorizing the issuing of a writ of execution, specifically directing the sheriff to sell Mr. Kellin's carefree Arizona residence. Your Honor, this path is something which has been dealt with in our case law and statutes for a very long time, and for several decades the rule has been and continues to be that an out-of-state debt incurred by only one spouse under ARS 25214C is not enforceable against the community property in Arizona.
Is there any dispute? Do you contest that that absent 25214C that the judgment could be executed against the party's community property? In other words, do you contest that it's a community obligation?
We do, Your Honor, and this
offer evidence at trial to show why the presumption doesn't apply?
Your Honor, this position is rooted in the statute that a community debt is a debt that is incurred by one or both spouses during the marriage. There are exceptions in 25214C for real estate transactions.
So what I'm trying to get at, as I understand your briefing, you don't really pause before getting to 25214. So you're kind of assuming that the presumption which ordinarily applies does apply here, except, and you're arguing that under 25214C it does not.
Correct.
Okay.
And that actually touches upon 25215C, which provides that the community property is liable for a spouse's debts incurred outside of this state during the marriage, which would have been community debts if incurred in this state.
Okay.
But so you say that this falls under one of the exceptions because this is real estate. But my understanding is that this is off of a deficiency judgment on a promissory note. not on the real estate itself, and not a deed of trust or anything like that.
Right. And the statute is addressed to transactions. That's the critical term here, transactions. The original transaction involves both a debt undertaking and a security instrument. The promissory note is the debt. The deed of trust is the security instrument. And so to say that any action taken on a promissory note post-foreclosure becomes simply an action on the note ignores the fact that the transaction, the root transaction, involves real estate under 214C1.
Well, but as I understand it, though, correct me, the real estate aspect of this is gone. The original real estate was foreclosed upon. So what we're dealing with is a deficiency that's left over after the real estate transaction is long gone. This may have had its the deal may have had its genesis in real estate, but this isn't a real estate transaction any longer.
Right. I agree that the real estate is gone after a foreclosure, but that doesn't alter retroactively the original transaction. And we have plenty of case law, and we cite even Utah case law, which says that when you have multiple documents which evidence the agreement, they're to be construed together. And yes, while the deed of trust is foreclosed and rendered a nullity, it doesn't change retroactively the original transaction involving real estate. Why is that important? That's important because the acquisition of title by a married couple during the marriage, whether it's taken in one name or both, still becomes community property. And in most real estate transactions, the documents are recorded one right on top of the other. So the warranty deed by which Mr. Kellin acquired these two condominiums in Utah is followed immediately by the next recorded item, which is the deed of trust. Why do title companies do that? So that they can ensure that the deed of trust taken by the lender is protected against intervening liens. However, in this case, the documents fall short because in the instant between delivery of title and execution and delivery of the deed of trust, the community, the Arizona community, acquires an interest in the property. And so to encumber that property, it's only in the name of one spouse. That is why we have the statute requiring both spouses to sign for not only the acquisition of real estate by contract and all the way through closing, but also on the deed of trust and the debt instrument.
So then your position is that your client sought to encumber the community but did not do so because 25214C would not allow it and would have required his spouse's signature?
I don't think there's evidence in this record of the intent to bind the marital community in the documents that were executed. And sorry.
Let me ask a couple other questions. So your position is that the property that was obtained in Utah was community property? Obtained as community property?
Yes, because presumptively property acquired during marriage is community property. Now,
but your position is also that the debt is not a community debt.
My explanation was, why do we have this statute requiring both spouses to sign for debts or debt instruments or deeds of trust on real estate transactions? Because the moment, imagine a different situation where a married couple buys property outright in both of their names and then later decides to borrow against that property under a line of credit, for example. The time frame between the acquisition and the debt, there could be intervening liens. And we know, whether the property is acquired in one name or both, that the community acquires an interest in the property. So a good lender will insist that both spouses sign on the line of credit undertaking. That's because, and that's no different than the situation where it's purchased money.
Sure, because it's the line of credit that's will be the basis of the judgment if the couple defaults. Have you got any cases for your assertion that in a case like this, where you have a note obligation and where you have a deed of trust given to secure the note obligation, the judgment for purposes of 25214C is based on the deed of trust rather than the note.
There's no judgment that's based on the deed of trust.
Well, okay. My point is, 214 talks about binding a community in the case of a transaction for the acquisition, disposition, or encumbrance of an interest in real estate. And the other side argues that this judgment arises not from the transaction acquiring or giving the security interest, but that's the note. That's the default.
Right, and I have heard the analysis that if this was a car, no problem, the deficiency would be enforceable against the marital community. The same thing applies for any unsecured debt. It would be enforceable against the community, but real estate transactions are treated differently.
They are, but my question is, have you got a case for the proposition that a judgment on a note falls within 214C because the security interest was given by way of a deed of trust?
Yeah, the Citibank versus Van Velzer case, the Superior Court, which was affirmed, the husband signed a debt instrument as, quote, an accommodation party. That was treated as a contract of suretyship, but it also fell under C1 because it was a transaction involving real estate. And that decision was affirmed by this court. So, and
the action involved the security. Here, the security's long gone now. We're no longer dealing with, as you can see, we're dealing with the deed of trust because that's been executed upon is no longer operative. We're not putting action on promissory note. And I'm having a hard time understanding how that the note is still tainted by the original real estate transaction when the real estate is no longer in the case any longer.
Actually, and factually speaking, this note does say, this is on the face of the note, this is not the deed of trust. It says this note is secured by a deed of trust. So I don't think you ever really, quote, remove the taint of the real estate transaction. And while this may seem like a result where a car loan or an unsecured loan would be enforceable, or as the bank has argued, they would have been better off not having a security interest or deed of trust in the first place. I get it. Banks hate this statute, and they come from all over the country. And I was the victim of the Rackmaster case because I had an appeal pending on behalf of a creditor that was stayed because of a bankruptcy. Then the Rackmaster case was decided, and I lost. And it's an unreported decision, so I'm not citing it, but I'm just saying that case came down, and it stood for the proposition that this is a substantive right of community property. It is not something procedural. And so,
but counsel, let me ask you: you mentioned the promissory note references the real estate and that it's secured by the deed of trust, but the promissory note itself does not acquire, dispose, encumber an interest in real property. Isn't that correct?
That is correct. I mean, as I said, every financed real estate transaction involves both a debt instrument and a security instrument. But you can't escape the designation of 25214C1. This is a real estate transaction, and you cannot bypass that statute by simply suing on the note or claiming that it was a community debt. Just trying to extricate the debt from the mortgage, it flies in the face of how real estate transactions are accomplished. So to say, well, the security of the collateral is gone, we're just suing on the debt instrument, and oh, by the way, now we somehow transmute that into a community obligation. That's not our law. That wouldn't be the law on a personal guarantee under C2 or property or a transaction after service of a petition for dissolution. So why should C1 be treated any differently than all of the C2 cases we have cited. And there's a long list of them. And Division 2 just held in 2017 that this substantive right that Rackmaster commented upon even applies to people who live in California in the Merari case. So it's not like you can just change the nature of the transaction retroactively to gain some advantage.
But I don't think you're going to find much disagreement with the court about the proposition that the statute applies regardless of whether of where the parties are when they enter into the deals. Rackmaster was a guarantee case. I've just looked up the Van Velser case and see that the court actually affirmed that based on the suretyship, on the guarantee, not on the connection with the real estate deed of trust. That's the problem I'm having. What can you say about that?
Your Honor, the interpretation of the statute and the path that this case followed to say that after foreclosure it's no longer within the scope of C1, what would C1 be there for? Why would we even have that paragraph of subsection C if every lender, every creditor could simply eliminate or retroactively make the transaction within the scope of 214B, where each spouse controls the management of the community? It doesn't just emasculate the statute, it effectively repeals it.
Well, the statute, though, is written, the sentence is written both in terms of acquiring, managing, or controlling a community property as well as encumbering it. So there's two different functions of that sentence in the statute. So I'm not sure that it emasculates or does away with the statute.
And I guess our point is that every bank could make the same argument on a real estate transaction where they made a mistake and didn't get both spouses and didn't check the credit of the person applying for the loan and say, are you married? Do you live in Arizona? We know about this idiosyncratic aspect of Arizona community property law, and we insist that your spouse join in this transaction or we won't make the loan.
Isn't the opposing party's position that your client represented that it was his sole property when asked those questions?
That's of record. I mean, that's an argument they've made of it's not really fully developed below. If the claim is that fraud occurred, the statute long expired to sue for fraud and say... Did your
client so represent that it was his separate property? I know there have been a number of transfers between SRK, your client, and the community. So at that time, did he represent that it was his sole property?
When a bank asks a borrower, like Mr. Kellin or anyone else, what do you own? They don't draw a legal distinction between separate property and community property, and I don't think there's anything on the loan application or anything in this record where it shows, please distinguish in making this loan application between your separate and community property. They just ask, do you have assets? And if the answer is yes, you haven't lied.
So your understanding of the record is that your client never asserted that it was his separate property?
I don't think that's of record here, no. There's no document in this transaction whereby Mr. Kellin said, I am well heeled enough that that you don't have to worry about it. This is all mine, my sole and separate property. No. Nobody makes that distinction when they make a loan application. Should lenders ask? Perhaps so. And the bank here wouldn't find itself in this situation. And thorough lenders know the law. It doesn't matter if they're in New York, Colorado, Utah, or Florida. They know that this law exists, and they make preparations and deal with it. I can't emphasize enough the import of the Rackmaster case, but also the Merari case that has come down, which basically reaffirms the substantive right to protect one's community property from an out-of-state debt for which only one spouse signed. There was no concealment of Mr. Kellin's marital status. The bank didn't do everything it could have to protect its interests.
Okay. Just to be sure, your position is that the promissory notes are not a community debt, but the property obtained was community property.
Well, it's foreclosed. I mean, so the time for a spouse to say, wait a second, that's my community property, that would have been before the foreclosure.
But your position is that it was community property, but the debt was not.
Presumptively, it is, but the debt is a separate debt because it wasn't signed for by both.
Thank you.
Good morning. May it please the court, my name is Steve Jerome, and along with my partner Ben Reeves, we represent AWB Banner Bank. And I don't want to waste all of my time going point by point with Mr. Lorenz and on everywhere. I will highlight the significant areas of disagreement, but I'm not going to be able to refute every single point. I think there's been some painting with a very broad brush and trying to pull everything in under one big umbrella, even though, as Judge Howe, you recognize, we're talking separate legal documents. So I'm going to try to break my argument into two sections. First, there are a few preliminary gatekeeper-type issues, threshold issues as set forth in our motion to dismiss, and then I'll deal with the 25214C arguments. Simply, Mr. Kellin does not have standing to raise 25214C on behalf of his marital community. And he does not have standing to raise the arguments that he's raised in his brief, which he has not discussed here at all, argument on behalf of SRK, which is a separate legal entity. Standing to raise an argument on appeal, to raise an appeal is different than standing to raise an argument on appeal, as this court has held in the Gogolo case at 156 ARS 12. In his opening brief, Mr. Kellin asserts, in Rackmaster, this court determined ARS 214C is substantive in nature. Mr. Kellin further states the statute was enacted to protect the substantive rights of the non-signing spouse. We agree. And in fact, in the Arizona Supreme Court case of Geronimo Hotel and Lodge versus Puzzi, in the Supreme Court, in addressing whether or not a lease was enforceable under 214C1, the Supreme Court said, quote, contracts falling within ARS 25-214 are not per se void, only voidable by the non-signing spouse. It went on to say, because only the non-signing spouse can avoid contracts under ARS section 25-214, contract provisions such as warranties that can be performed by the signing spouse without injuring the community shall be enforceable against the signing spouse. And that's at page 479. So the Supreme Court has said only the non-signing spouse can raise these issues because the contracts are void, not voidable. So even if he's right, which he's not, and I'll get to in a second, he doesn't have standing to raise those arguments.
But this is not. This is the different phrase in the statute. This is not about voiding a contract. This is binding the community on an obligation, and we're having quite a discussion about this. It seems to me that a spouse in Mr. Kellin's position could very well have a benefit. I mean, if he prevails here, he will have benefited by the absence of his wife's signature on the note or on the deal, because he gets to retain his community. The community interest in the home is not attachable under his argument.
Correct.
So hasn't he benefited in that regard?
He has benefited, and I will jump ahead in my outline, and I will come back to the threshold issues, time permitting, at the end, because I think, and it will take me a second to get to the answer, but we need to break down the transaction. And generally, unless one of the three narrow exceptions apply, one spouse can bind a community. So let's talk about promissory note. Just like if I go out and fill out a credit card application, that binds my marital community whether my wife signs or not. Promissory notes are no different. In fact, this court in Bainham versus Roundy held, it, quote, it is well settled in this state that execution of a note by the husband, in the absence of any evidence the obligation was not a community one, binds the community composed of the husband and wife. And again, in Johnson versus Johnson, this court, when analyzing there was a promissory note, and it was collateralized by sole and separate property. And the argument was, well, since it was collateralized by sole and separate property, clearly this must be a sole and separate debt. And the court stated, quote, "The mere fact that the borrowing spouse's separate property was used as security for the loan does not overcome the presumption that a debt incurred during marriage with the intent to benefit the community is a community obligation." So now let's talk about where Mr. Lorenz wants to say this is all one big transaction. That's not how the law of commercial transactions works, nor is that consistent with the case law in the state of Arizona. In Hogan versus Washington Bank, which is a 2012 Supreme Court en banc decision, it was a show-me-the-note case, mortgage foreclosure case. The Supreme Court went in great detail to explain the difference between a note and a deed of trust. Quote, "The note and deed of trust are nonetheless distinct instruments that serve different purposes. The note is a contract that evidences the loan and the obligor's duty to repay." And then it cites ARS 33-8014. "The trustee transfers an interest in real property, securing repayment of the money owed under the note." That's not an outlier. Same year, this court in National Bank of Arizona versus Schwartz, when addressing post-foreclosure deficiency, that whether it arises under the note or the deed of trust, in deciding whether to enforce the arbitration provision that was contained in the note, this court stated, quote, "The debt arises from the promissory note. It is contractual. Such debt may be secured by a deed of trust or mortgage." And then skipping a few lines, "Rather than the deficiency flowing from the foreclosure, as asserted by the bank, the debt and all potential recovery flow from the promissory note. That has long been the case." And then more recently, in ZB versus Hohler in 2017, this court analyzed different choices of law provisions that were involved in a note and a deed of trust. And the court in ZB said some very important things that directly impact Mr. Lorenz's argument. Quote, "The basis of ZB's action against the borrower is the deficiency borrowers owed to ZB on the promissory note after foreclosure of the commercial property. This action has no effect on any interest in the actual property." The court went on to say the deed of trust is effectively extinguished after the trustee's sale of the security property. So what do we have if we look at the record, and it's our record at 58, which was Exhibit W to the post-judgment motion, is the Utah complaint. It sought judgment on notes, 2 promissory notes, and it attained judgment on 2 promissory notes. So when you look at 25-214C1, I mean, Mr. Lorenz keeps referring to Rackmaster. That was a guarantee case. This is a note. This is vastly different. C2 does not and cannot apply. And C3 cannot apply because there's nothing in the record to indicate that there has been any petition for dissolution of measure, and that's an argument. So the only argument that's possible is, was this a transaction for acquisition, disposition, or encumbrance of an interest in real property? And that gets back to your question, Your Honor, of where you're voiding the contract. If I have a contract that transfers an interest in real property, acquires an interest in real property, encumbers an interest in real property, when we're looking at the bundle of sticks, go back to law school where the realty example was always that real property rights are a bundle of sticks. You may transfer all of them, one, some, but you're transferring rights. Are any of the bundle of sticks being transferred in a promissory note? The answer is no. And that's what the statute protects. If you have a community interest in real property, you can't transfer any of those bundles of sticks without both spouses' signature. But that's not that is the deed of trust. So had this been an Arizona real piece of real property and an Arizona deed of trust, and the property was community property, as Mr. Lorenz contends, and there was only one signature on the deed of trust would have been invalid. And that would have been a defense to foreclosure. But that's not what we're at. That would not invalidate the community nature of the debt, because you still have a promissory note, which is a separate transaction.
Can you help me understand the relationship between the Superior Court's unwinding of the transfers of the carefree property under fraudulent conveyance statute and the other part of the court's ruling? In other words, if we were to conclude that the court did not err by ordering the home to be subject to a forced sale, by way of execution of the Utah judgment. In other words, if we were to conclude that the statute doesn't accept this transaction from the general rule, would we need to address the fraudulent conveyance section of the ruling?
No.
Well, why not? Because don't we have to get to a position where the home is community property?
You do not, because of two reasons. One, this gets back to one of my threshold issues. SRK is a limited liability company, a Wisconsin limited liability company. And as cited, I think, on page 10 in our motion to dismiss, there are a raft of cases that assert that the transferor of a fraudulent transfer does not have standing to contest the unwinding of a transfer. The legal owner of the property, SRK, was served with the post-judgment motion and defaulted.
But
and so has waived any argument that any mechanism to get to the property that it's being deprived of is defective.
I thought the transferor in this scenario would be the Kellins.
Correct. And they don't have standing to assert that the mechanism to seize SRK's property was improper. That's where he's lost appellate standing, because that would have been a defense that SRK could have raised and chose not to by choosing not to respond to the motion, the post-judgment motion, which specifically sought execution against their property.
So the argument that you're positing assumes that the transaction is not unwound, that SRK holds title, and you're saying SRK didn't object to execution of the judgment against it.
I'm saying that it doesn't matter either way, because if you unwind it, unwind the transaction as the court did, and assume it becomes community property, then 214C1 does not apply. Right. So it's not an issue. And the only party that can complain that the Superior Court's authorizing execution against SRK is SRK, who did not oppose the motion and has not appealed, and Mr. Kellin just simply lacks standing to litigate those issues on its behalf. And that was going to be one of my threshold issues, was, we look at corporate entities are separate and distinct from their members. Courts don't allow individuals who own an LLC to show up in court and represent that entity pro per. We say it's a separate entity. That entity needs, you can only represent yourself. You need to go get accounts. It's the same. There is no case law that says, that Mr. Kellin has cited, that he gets to litigate SRK's rights in the property. So if SRK's rights are wrongfully being taken, it had notice, opportunity to respond, and chose not to, because they're all represented by the same counsel.
Is that the rule even in the case of an LLC that's owned entirely by a community?
I'm not sure I understood the question.
Is the standing rule the same in the case of an LLC that's owned by a husband and wife only?
When you're talking about representing in court, I've never seen a court authorize there are a few exceptions where there's maybe certain administrative proceedings where individuals are allowed to represent both corporate entities, but it is a limited liability company. It is a corporation, a corporate entity, and if you're talking, significant litigation in front of the Superior Court, I've never seen a court authorize that, and I've seen orders issued, minute entry order saying it needs to have counsel. Now, is that binding precedent? No. But I've never seen it authorized, because I think that is essentially we would be disregarding its corporate separateness, and that would essentially allow a lot of mischief and fraud and say, well, for some purposes it's separate. I mean, reason why corporate entities are formed to shield liability and to create separateness, and now they're saying, well, it could just be disregarded whenever we want. That's not exactly a positive policy decision. So again, going back to the 25214C1, the three cases that I went through, if you distill out kind of the key points of those, Hogan held that the note and deed of trust are distinct instruments that serve different purposes, that the note is the contract for the debt, and that on the other hand, the trust deed is the vehicle by which you transfer one of the bundles of sticks in the real property.
The promissory note itself gives no rights in the property, correct?
Absolutely correct. The note standing by itself does not convey any right, title, or interest in any real property.
It can refer to a deed of trust all at once, too.
Right. because again, you're referencing to what the Supreme Court has held as a separate and distinct contract. They are, one is dependent on the other. You can't have a deed of trust without a debt, but you can have a debt without a deed of trust. And that's also what this court did in NBA versus Schwartz and ZB, is saying once you're post foreclosure, the deed of trust ceases to exist, and this is an action on the note. And therefore, since it's an action on the note, it doesn't fall within the exception. And Mr. Lorenz kind of said, offered a parade of horribles by saying if you could end run this statute, every bank would do this. That's not true, because this only comes up when you're dealing with unique circumstances of bringing judgments from non-community property states to community property states. And only it applies to, so what he's saying is, if we're talking an Arizona transaction, as I mentioned, if the deed of trust wasn't signed by both, that grant of security would be invalid. It would be a complete defense to foreclosure. So it doesn't eviscerate the statute. The statute doesn't apply to the debt. It only applies to the document that transfers one of the bundles of sticks. And that doesn't happen here. There's also an allusion in the briefing to, well, and I guess even if we get to, and I don't believe the court was going to go there, somehow that there was some sort of, that it does apply. Well, Geronimo has also told us that transactions are not void, they're voidable, and they can be ratified. Specifically, the Supreme Court held contracts falling with ARS 25214 are not void per se, only voidable by the non-signing spouse. I'm citing omitting an internal citation. The non-signing spouse could, for example, validate a lease by accepting payments or otherwise consenting to the agreement. In this case, in the post-judgment enforcement activities in Utah, there was some litigation over an investment account. Both Mr. and Mrs. Kellins participated in that argument in Utah and argued the same arguments they're making here, both under Washington and Arizona law. In that jurisdiction, they claim to be Washington residents. Here, they're claiming to be Arizona residents. But here's what the Utah court found. Transactions that form the basis of the claim in this case were for the purchase of marital property. The property was held out as marital property by both Mr. Kellin and his spouse, and the purchases were made with marital property. So even if you had concerns that 215C1 applied, Geronimo says it can be ratified. The Utah ruling indicates that the ratification occurred, and we need to look no further. The last issue that seems to be of some consternation for Mr. Kellin is this argument that Mrs. Kellin needed to be joined in the underlying litigation in Utah. And again, that is just simply not Arizona law. Arizona law is clear in both National Union versus Green and Alberta Security Commission versus Rickman that where you're bringing a foreign judgment from a non-community property state, Arizona does not export its procedural law requiring joinder of both spouses to make the judgment enforceable. And in fact, what Green has stated, neither the time nor manner were meaningful when the suit was brought in New York because there was no threat to property then. The time became meaningful, however, when the writs of garnishment were issued in Arizona.
Well, isn't the premise of the whole legal question here, it assumes that the judgment is against one party, not both.
Right, because
that's why we're in.
Because in Arizona, you get a judgment against sole, separate, or community. In Utah, it's one or the other. There is no third option to check the box with. And so we have to give, so as National Union and Green recognize, we have to give full faith and credit to foreign judgments of sister states that are not community property states. So then we have to determine, is the community in Arizona liable? How do we do that? We give the non-signing spouse, the non-named spouse, notice in the enforcement action. In Green, it was a garnishment. Here, it's in a post-judgment motion. And then that's when that non-signing spouse under Geronimo has the option to challenge and say this transaction was voidable as to me because I did not sign. So she did not challenge. In fact, went out of her way not to challenge by filing a separate response to just the discovery portion. She could have just as easily joined in her husband's response, but for what appear to be tactical reasons, chose not to. So she didn't oppose it. Mr. Kellin can't assert those rights.
Does the record tell us whether there's a homestead exemption on this Carefree property?
The record does not tell us whether there's a homestead exemption because, again, it's titled in an LLC, so which would, on the face of the statute, not be entitled to a homestead exemption. So unless the court has any further questions,
Thank you.
thank you.
Your Honors, I want to begin with the standing issue. This argument, it made in the motion to dismiss and in the briefing, would effectively eliminate the entire claim, because what the bank is saying is they're jumping from one foot to the other, and they're saying, well, it's not Mr. Kellin's property, so it's not his place to object. First of all, that puts form over substance. Everybody knows that the Kellins own SRK as their community property, and that SRK is the record title holder. If they have no lien against, if SRK is the owner, they have no right to execute against its property. So why are we even here? If that's the route the bank wants to go and start over and try to come at a different angle, fine. But we shouldn't be here if they have no judgment lien against SRK's property. They say, well, Mrs. Kellin should have jumped in and intervened or something. Why didn't the bank sue her? They can sue on a judgment. That's a perfectly acceptable way of proceeding to enforce a judgment. You sue on the judgment of another state. You can sue on a judgment of this state. You can renew by affidavit or do whatever you want. I just want to conclude by saying the Rackmaster case is on point here. We can't just ignore it using some way to try to pull apart what everybody recognizes are two component parts of the same transaction, the debt and the security. They're not separate transactions. They're one transaction. And the court cannot take away what the legislature has done in this statute through a ruling.
Before you sit down, I want to ask you about something, an issue that you concluded the prior session with us about. The Utah condos, Mr. Kellin bought those with a partner or without a partner, one with, one without?
As to one of them, yes.
Okay. He had a partner with one, no partner with the other?
Yes.
He took title to those as his sole and separate property, right? Does it matter?
My memory is a little foggy on that aspect of the record, but I believe that Brent Bryson was the other.
But was Mrs. Kellin involved in those transactions?
No.
Okay.
No.
So the Utah properties were not held by the community. Whatever interest Mr. Kellin had in the properties, that was his sole and separate. Unless you want to trace back the funds.
If you asked Mrs. Kellin in the event of divorce whether she owned something of value, she would say, well, that was acquired during the marriage.
Okay.
That's presumptively community.
Although she didn't execute the
Correct. And the grantee of the
purchase contract,
deeds
yeah.
is of record, and that's Mr. Kellin alone.
Okay.
Does that make it his sole and separate property? Presumptively, the answer is no.
Got it. Okay.
Thank you, Your Honors.
Thank you very much. Thank you to both sets of lawyers for your briefing and for your argument. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.